Good morning and welcome to today's webinar, an overview of the past year with regard to the various fiduciary regulations and initiatives that have been undertaken. My name is Steve Wilkes. I'm with the Wagner Law Group, the partner in charge of our fiduciary practice group. I work out of our San Francisco office, and I'm joined by my colleague Livia Aber of Counsel and very senior attorney in our Boston office. Hope you all had a nice Thanksgiving, and thanks for joining us today. What we're going to talk about today as we go to the agenda, and what we're going to try to accomplish is just give you a sense of all the activity that has been undertaken with regard to fiduciary initiatives over the last year. It's really quite overwhelming. It's not just the DOL, it's the SEC, various trade groups, the insurance industry. So I think it's important to understand as we swing around into the year 2019 that there are multiple regimes in play, regulatory initiatives, various regulatory bodies, and it's just good to have a perspective. So our purpose today is not to necessarily educate you on every detail of every initiative, because we know that we've all been talking about it and learning about it together over the last year or so. It's really just to call out and highlight the scope and the depth, if you will, of all the activity that's going on, and give us all a little perspective for next year. Some of the slide, we gave you a very full PowerPoint slide deck, and we're going to use our judgment to move more quickly through some of the slides than others, but the entire deck will be available for you to view online and when this webinar is otherwise available on audio. So again, thank you very much for joining us. Let's take a look at the specific agenda that we're going to talk about. Slide, please. So obviously, we're going to be talking about the state of rulemaking with regard to the fiduciary rule. Looks like we're having a little trouble moving the slide. We'll see what happens. But let's start off with a little recap of the events which have taken place, which ultimately led to the death of the fiduciary rule. So after we do that, we'll talk about the current rules that are applicable, under today's environment, including the DOL 5-part test, the DOL advisory opinion, FINRA notices. Thank you. We'll then go to a discussion of some of the SEC activity in this area. We'll talk a little bit about Dodd-Frank. We'll note the 3 proposals that the SEC has come out with. And then, of course, we'll also make note of a few of the standards put out by such bodies as the CFP Board, the National Association of Insurance Commissioners, and then we'll try to give a sense from our experience here at the Wagner Law Group where we see some of the trends and how people are responding in the marketplace. Slide, please. So, very quickly, everyone knows this history. When the DOL adopted that fiduciary rule a number of years ago, and it was a proposal and then withdrawn and reproposed and so on and so forth. Ultimately, we had what they thought was going to be a final rule. I don't think they really felt that a challenge to those regs would ever be upheld, but a series of court cases proved them right. But last March, in a decision that surprised a lot of people, the Fifth Circuit in the U.S. Chamber of Commerce case issued an opinion that said the fiduciary rule and all the related exemptions, including the BIC, the best interest contrast exemption, were vacated. And the DOL had the chance to request a rehearing or to go to the Supreme Court. The DOL didn't do any of that. Several states and the American Association of Retired Persons tried to intervene. Fifth Circuit rejected. So at the end of the day, the rule was vacated. The Fifth Circuit said it was too burdensome and onerous and broad. They rejected the DOL's reliance upon the deference that is typically shown to rulemaking by an agency, under the Chevron case. And they also noted that they thought the DOL had overreached the way they had reached out to regulate services and providers was beyond its authority. It kind of cut in on the turf a little bit of the SEC, as set forth in the Dodd-Frank Act and so on. So on June 21, the mandate was issued and the DOL, rule was dead. Slide, please. So it's important to note now what a lot of people are relying on is the temporary enforcement policy, because the DOL has yet to really come out clearly and tell people where we're at today. So everyone kind of assumes, and I think rightfully so, that we're back to the old 5-prong test, We're back to some old advisory opinions, what have you, but the DOL advisory, the DOL has a temporary enforcement policy, which came out in the form of a field assistance bulletin. It's very important for people to note, 2018-02. And what they're really saying is that from that June 9th, going back from June 9, 2017 until we either get new regulations or some other guidance, the DOL is not going to chase any prohibited transaction claims, and the IRS won't impose any excise taxes against people that are working diligently to comply with impartial conduct standard. Please note a couple of things. This lull in enforcement, provided that you show good efforts, doesn't impact the right of private parties to bring class action, state regulators. There's always a creative way to bring a lawsuit and get involved, but that's the stance of the DOL. And I think a lot of people are because they work so hard to meet the impartial conduct standards, are going to be hanging with that for a while and kind of relying on it as a, if not a permanent, at least a temporary measure by which they can pursue their retirement business. And also remember, this is for advice, not discretion. Discretionary management of assets has a regulatory regime of its own from the DOL. We're talking about advice scenarios. So that's where we are. They left open a couple of questions, in terms of, what the current law is, but that's, at least we know that we have a safe harbor, if you will, for enforcement by the DOL, and that the impartial conduct standard is going to be there to guide us. Next slide, please. I'm not going to go through a lot of detail on the old DOL 5-part test. Many of you know it and remember it. It's just interesting to note, what's old is new again. So I think everyone pretty much agrees that the current state of the law is the 5-part test, though we haven't really heard it officially. And, they looked at, key factors, like advice given on a regular basis, mutual agreement. It had to be the primary basis, individualized. I think those are the components that are still in place. Please remember, the DOL was pretty critical of this, in the proposed and reproposed and ultimately the final regulation that came out, which is now vacated. So we're not sure, the 5-part test is out there. It might be read or interpreted a little bit differently now by the DOL than it was in the past. I think the SEC tends to be following along with some of their proposals at the retail level. So I think people need to be careful about the temptation of saying, aha, we're back to the old days, we're back to the old 5-part test. We are, but I think we have to understand it and apply it in a different way. Slide, please. A lot of activity, of course, it relates to plan distributions and rollovers, because you'll recall the old advisory opinion in 2005, I always call it the dessert opinion, but this advisory opinion had been superseded by the fiduciary rule, and under the rule, it was pretty clear that any recommendation touching a plan distribution or rollover was going to be advice, and earning additional comp by rolling over was a prohibited transaction, for which you had to satisfy the BIC relief, or maybe the level exemption part of the BIC. But now we're back to this rollover opinion, and what they're really saying here is that if you're a fiduciary, any advice you give about a rollover is going to be problematic, be it a prohibited transaction. If you're not a fiduciary and you kind of come in with clean hands, it's okay. This was sort of the tension between the, quote, registered rep broker-dealer community, close quote, which, often said that it was not a fiduciary and they had a better shot, a clearer chance to go in and work on rollovers. And planned fiduciaries felt, somewhat constrained, if you will, or there was a competitive disadvantage. But there are some workarounds. There are some things that can be done here to stay within the confines of the advisory opinion and the standards of fiduciary conduct that apply to rollovers, and that would involve, things like it's a little bit murky, but it involves things like, having the ability to take your fiduciary hat off and speak to a plan participant in a different fashion, provided you give good disclosure, and maybe the participant acknowledges that you're now speaking in a different voice. So there's some things that can be done in the agreements and structurally in terms of the script and the dialogue and the steps that are taken to work around these issues, but they're very tricky and you really need to be careful. Next slide, please. Of course, we still have FINRA's Notice 13-45, which is a really good notice. I think a lot of people look at that and say, wow, that's a great list of criteria for just good, prudent and fair investment advice regarding rollovers. So FINRA and the SEC have a stake in this notice. Recommendations to rollover plan assets, we think should conform with this notice. Advice has to be suitable for the participant. Thinking about things like, investment profile, age, outside investments held away from the IRA, overall financial situation, what kind of financial planning is going on around the rollover, and so on and so forth. So it's also important to do this in a manner which clearly shows, and the evidence trail shows that there are no conflicts. And you can't let, advisors can't let incentives or any kind of financial incentives get in the way of how they handle a rollover. It was truly in a participant's best interest to leave a balance in a plan, for example, as compared to a rollover. If that's really the best decision for that participant, then that should be the decision. Well, we hear a lot from our clients. There are a lot of participants who will say to the advisor, hey, you know what? I know it costs me a little more to leave it in the plan, or my investment opportunities are not as broad as what you could provide for me. The investment choices might be different, I should say. But you know what? I want you to handle my assets. You don't have access to my account when it's in the plan. You can have access to my account if it's outside of the plan. I want you to do this for me, even if it costs a little more. So then it becomes, of course, a participant decision, and you're really not talking about advice. But that happens quite often. Next page, please. The SEC has been very active. It remains to be seen where this all is going to play out. The SEC has issued a set of 3 proposed rules that all started, with the enactment of the Dodd-Frank Act, where they talked about the possibility of a uniform standard of conduct, and the Dodd-Frank Act, required the SEC to evaluate all the different rules, legal or regulatory standards or gaps that were in place regarding fiduciary standards, and it was kind of a trigger for action. Next slide, please. I'm not going to go into too much background on the Dodd-Frank Act, but it's there. They have a tremendous study that's been put out on the SEC webpage that you should read. The study on advisors and broker-dealers. It's really interesting and very helpful. Next slide, please. So the SEC in April of this past year, they put out 3 proposals. They gave us a release for the standard of conduct for broker-dealers, Reg BI. They gave us another release that talks about delivering a new form CRS, and another release that really codified the interpretation of what the fiduciary standard is under the Advisors Act. And they asked for comments on it, but it really is kind of a codification of everything, from capital gains and what have you. Now remember that Reg BI is separate and apart from the fiduciary duty that comes under the Advisors Act. It doesn't have any effect on the SEC's interpretation on the scope or nature of an advisor's fiduciary obligations. So these things have to be read in the proper context. Slide, please. Reg BI is very quickly just, standard of conduct, best interest obligations, acting in the best interest, whatever that means. At the time a recommendation is made, we think we know what recommendations mean. That's a term of art. Without placing a financial or other interest of the advisor or an associate of the advisor ahead of the interest of the retail customer. Again, all terms of art that require some clarification. Interesting here, the Reg BI is saying that a broker-dealer certainly can't waive compliance. A retail customer can't waive protection. And unlike the old best interest contract where IRA holders, for example, had a private cause of action, there is no private rights or actions or rights of rescission that come along with this. Who's going to enforce this? FINRA, SEC, it all remains to be seen. The next couple of slides, regulation BI on best interest and recommendation, I'll leave those for you to take a look through. They're interesting. They're probably capturing some of the things that you already know. It does apply to, please remember, it applies not only to securities transactions, as we call out on slide 15, but investment strategies, methodologies. This is the definition that can be pretty broad. So it's not just the sale or purchase of security. It could be the strategies and methodologies that go along with it. Retail customer is also an interesting concept on slide 16. It's defined in the Dodd-Frank Act. The SEC proposal, this is going to define a retail customer pretty narrowly, really. It's any person or legal rep of a person who gets a recommendation concerning security, who receives, I should say, a recommendation concerning securities or investment strategies, and then uses the information for personal, family, or household purposes. So they're really trying to drill down on who a retail customer is. Interestingly, so, an IRA owner or plan participant, they seem to meet that definition and be a retail customer, but a sponsor, another plan fiduciary, doesn't appear to be a retail customer. What standard applies when you're talking to them? These are all things that need to be worked out. There's some gaps out there. The next couple of slides, just for your own information, get into some more detail on the components of the best interest obligation, disclosure on slide 18, what kind of material facts have to be disclosed on slide 19, when you have a conflict of interest on slide 20, a material conflict of interest. Something that a reasonable person would expect might incline a broker-dealer, either consciously or unconsciously, to make a recommendation that is not disinterested. There's going to be lots of discussion around that. On the one hand, it really kind of makes sense when you think about it. It resonates as, I think I know what that means. But when you really dig in, you could probably drive the truck to that definition, and it leaves a lot of openings. So there are a lot of terms here in this proposal that will require some more definition. Page 21, defining the standard of care. The care obligation is satisfied if a broker-dealer or its registered rep exercise reasonable diligence, care, skill, and prudence to understand the risks and rewards. They have a basis to believe the recommendations in the best interest of the customer based on that customer's profile. And also, they string together. They have a reasonable basis to believe that a series of recommended transactions, even if in the retail customer's best interest when viewed in isolation or one at a time, it's not excessive. And when you put them all together, it's really in the customer's best interest when taken, when you look at the overall profile. I think that's an important concept to make. You can't carve out one transaction at a time, but you have to connect the dots when appropriate with a series of actions. So on slide 22, we have some more information for you on, the obligation of care, and reasonable diligence that, one would undertake, in exercising those standards. Going through slide 24, more detail there for you, more summaries. Slide 25, if you're trying to find out this information, we get this question a lot. What if I try to find out these things and I can't get the information from a plan? The customer doesn't have it. If the customer's information is unavailable despite reasonable diligence, which I think you must document to be able to show evidence of, then, you have to make the decision. Do you have enough information to evaluate whether a recommendation is in the best interest? So, if a broker-dealer knows or has reason to know that a retail customer's investment profile has changed, you have to make a reasonable effort to at least obtain that information prior to making a recommendation. But unless, I think, absent knowledge that the customer's profile is inaccurate, I think broker-dealers will have a reasonable basis, to rely on that information in an existing profile, provided that you had good steps and diligent steps and kept good documentation in terms of how you created that profile to begin with. More information on slide 26 about what I talked about before, a series of transactions. Slide 27, some detail on the conflict of interest obligation. Two elements, really. The first element there is that the broker-dealer has to establish, maintain, and enforce policies and procedures reasonably designed to identify and at a minimum disclose or eliminate conflicts of interest associated with the recommendation. We live in a world now, you've heard this before, of documentation. You just need to paper everything, file everything, document, just to show evidence of the steps that you've taken, undertaken, and compliance people should be implementing this process and then supervising its implementation. Very, very important. All these policies and procedures we're talking about, we think, the SEC gives broker-dealers a lot of flexibility, but we think that policies and procedures, clearly have to show how you identify conflicts and how you, especially conflicts that arise from financial incentives, how you deal with them, how you kind of review and monitor your systems. You have to have a process, to escalate identified instances of noncompliance to appropriate people for remediation. clear lines of responsibility for supervision along the different business lines of the firm, periodic review, and training, internal training ongoing. Those are all things that are important. Over on slide 29, we have more information for you on, on conflict of interest. Here, the SEC is saying that clearly they have an eye on incentive compensation practices, not only based on production, but bonuses and contests and special awards. They really are taking a hard look at different compensation schemes. Any compensation sourced from a third party. They're also very focused on compensation that derives from the sale of proprietary products or principal transactions. So that's a lot that we just went through. We know you've heard it before. I think we just tried to summarize it easily for you. So you've seen kind of the DOL, going back to the 5-prong test. You've seen the advisory opinion. You've seen some of the things that the SEC is talking about, which we all need to be following closely. But there are some other things that the SEC brought up as well. So I'll ask Liv to maybe talk a little more about the SEC at this point.
Okay, thank you, Steve. So the SEC released 2 other proposals along with Regulation BI. There's release number 34-83063, and it pertains to the new Form CRS, which would require broker-dealers and investment advisors to deliver to retail customers a short summary that would disclose the principal types of services offered, the fees that the retail customer has to pay, the legal standard of conduct, and certain conflicts of interest. The proposal would also restrict broker-dealers and associated natural persons from using as part of the name or title advisor, spelled both ways in certain circumstances. Let's move on to the next slide. I want to note that very recently, on the 8th of this month, the SEC released the results of its investor testing of proposed Form CRS, and the results were quite mixed. The testing consisted of an online survey of approximately 1,800 people, and then they conducted in-depth interviews. Now, with respect to the survey, the respondents generally provided positive feedback about the form and content of CRS. 90% of them said it would be helpful and that it would help them make more informed decisions, that it would be helpful to understand key terms and conflicts of interest. With respect to the interviews, however, participants said that Form CRS improved their comprehension, but they also reviewed a few areas of confusion, including the different types of accounts and the different types of service professionals. They also found that certain sections, such as fees and costs section, the obligations, and the conflict of interest sections, were a little bit overwhelming. So I think the SEC has its job cut out for it. It has said that it is looking closely at the report. The third release is release number IA-4889. And as Steve had mentioned briefly, here the SEC proposed an interpretation of the fiduciary standard of conduct for investment advisors and sought comments on proposals to modernize and enhance the rules regarding the standard of conduct. For example, the SEC requested comments on whether there should be certain potential enhancements to investment advisors' legal obligations by looking to areas in which the current broker-dealer framework provides investors with protections that they may not have counterparts in the investment advisor context.
Okay, thanks, Liv. The SEC is really, just going back for a minute, we were wondering for many years, going back 4, 5, 6, 7 years ago, gee, the DOL, I think the SEC and the DOL, they're clearly working together now. It seems as though they might have missed a chance to work more closely together 5, 6, 7, 8 years ago. That's just my view from the peanut gallery. I don't know that for a fact. I mean, I'm sure I know that we know they were talking with each other, but it's really interesting to see the SEC step up and put down a much stronger footprint on this now, and it's all welcome. There's a lot of interesting and good material coming out. If you go to the next slide, the SEC has got a lot of comment letters. For those of you that are listening, say that are, compliance officials or attorneys or just love the detail, there have been thousands of comment letters received on this stuff, different investor groups, financial firms, really interesting. And if you read through them, it's really quite a tour of the world in terms of the different issues that are out there and how people suggest they be resolved. It's really quite educational and interesting if you like to follow that kind of thing at that level of detail. The comments are looking for the SEC to strengthen and clarify, BD standards on suitability. A lot of people think the proposed standards are pretty much the same or maybe only a little bit better than the current suitability under FINRA. Investor groups said the same thing. They don't think that the ban, for example, on sales contests was strong enough and that, there should be harmony among the broker-dealer and the investment advisor community. Financial Planning Coalition submitted a very interesting comment letter back in August. Of course, they represent, not only the Financial Planning Association, but the Certified Financial Planner Board of Standards, which is a national association of personal financial advisors. Pretty good groups, pretty high standards of conduct. It was interesting, even though it wasn't a formal comment per se, but the AARP and the Consumer Federation of America, as Liv mentioned before, they wrote quite clearly that all this is really doing is because you have different standards for advisors and broker-dealers is adding to the confusion, you're really not solving anything. They came out quite steady on that, quite strong on that, I should say. The National Society of Compliance Professionals, NSCP, our firm is pretty involved. They came out with some excellent articles as well. So the next slide. Internally, the SEC has an investment advisory committee. They had 4 main recommendations, basically to clarify best interests, give us more substance on the definition, clarify that the best interest standard is a fiduciary duty, expanding Regulation BI to cover more types of accounts, address rollovers more directly, for example. And again, they, as Liv mentioned before, they added a comment about the Form CRS that is under consideration as well. Slide, please. So the politicians are involved. Senator Warren of Massachusetts, Senator Booker, New Jersey, Senator Brown of Ohio. They've been writing FINRA and inquiring about this stuff, and FINRA has, been interacting with them. So clearly you have different you have legislative bodies involved. We have the SEC, a regulatory agency. We have FINRA, which is really a self-regulatory body authorized under the Exchange Act. There's, a lot of people here are interested in the substantive issues, the cost of implementation, who has turf, who's in charge of supervising, so on and so forth. Page 36, a few more comments on the slide 36, I should say. The Certified Financial Planner Board, as I mentioned before, was part of the coalition that submitted comments. And they just, they recently put out their own internal standard, which is going to be effective October 1, 2019. It's a good benchmark for, fiduciary principles and conduct. They went out of their way to state that it doesn't cover, pure financial planning services or CFP it doesn't cover CFP professionals who are not involved in providing financial planning services. I should say it's kind of meant to be an internal guideline, but I think a lot of people will be looking at it because the CFP industry, sets some standards here. They place a lot of emphasis just on judgment, disclosure and management of conflicts of interest. There's no audit requirement for compliance, interestingly, and of course the CFP Board doesn't bring enforcement actions, but this is a way where a very large, prestigious group, licensed group in this country will be policing itself. On the insurance side, if you look at slide 37, remember here that, variable annuities are securities, and the insurance industry has been very much involved with, different forms of annuity contracts. How are they exempt? Should they be, is it a security or not a security? Do they have to meet the BIC, or are they satisfied by other exemptions? That stuff is still going to be out there. But the National Association of Insurance Commissioners, they had a working group, and about a year ago, they proposed several changes to the model language concerning the suitability and annuity transaction model regulation package they put out. There have been various iterations since then. It's really something that's worth following. They define suitable as a recommendation of an annuity that is consistent with the consumer's insurance needs and financial objectives based upon facts disclosed by the consumer or known at the time of the recommendation. And, of course, terms of art, consistent with furtherance of needs. These are terms of art that generate a lot of debate. They also talked about the duty owed by the insurers and the producers with respect to their own interests. And they kind of track what we've seen in some other language. They say these products can't be sold or advised without placing, they have to be wary of placing the producer or the insurer's financial interest ahead of the consumer's interest. So kind of tracking on the same thing. So it's interesting just to remember here that when this model regulation is finalized, it's ultimately up to individual states to implement it. They can deviate if they want, but I think that the NAIC, like some other groups around the country, is widely viewed as kind of the voice of the insurance industry, and the recommendations they come out with and the implementation they would like to see will certainly have some weight on the sale of insurance product. On slide 38, so let's stop for a second. Let's talk a little bit about where we are. As you can see, there's a tremendous amount of activity. DOL, SEC, legislators on Capitol Hill, National Association of Insurance Committees, groups like the Certified Financial Planning Board. Everyone has some stake in the ground. They're talking about what should and shouldn't be on fiduciary standards, who should have some control. So kind of like what's happening at the moment, where does that really leave people? I mean, clearly, we saw a trend that had been developing for a while, and that continues now. The fiduciary rule and the BIC exemption and the related exemptions that came along clearly encouraged and continued the migration, toward level fees, toward the advisory platform, and toward a lot of investment-related services, and a lot of firms have tried to, eliminate or squash out, if you will, all kinds of revenue sharing, third-party payments. And clearly people that, many firms that used to argue that they fit within, that they could avoid fiduciary status under the 5-prong test. I think most firms, some reluctantly, some more aggressively, if you will, have accepted their status as fiduciaries. When you're sitting now with retail investors, at the end of the day, we're probably, we're giving advice. That's usually what happens. So I think the industry has moved that way. Let me just make one side comment. There still is a good place, an important role for commissions and revenue sharing payments, other kind of payments certainly are payments that help move product and shape the formation and manufacture and distribution of product. I don't think they're going away. I think, the manner in which they're paid, the disclosure, the way you earn them, these are the things that are really being considered. So, a lot of firms, have had this debate internally, and we think the trend, like I said, it appears to acknowledge fiduciary status. Clearly, it's moving toward conflict-free fee structures. It's clearly going toward level fees. Our clients have decided to maintain a strong commission-based structure. We have some, and they do so, we think, appropriately. There's certain high net worth clients or transaction-oriented clients, that might have proprietary funds, or it's not necessarily an ERISA-governed plan. It could be a buy and hold client. We don't necessarily need to have an advisory fee or your law. It could be, once or twice a year to make some trades, and the portfolio is good. We also want to note that, as I said before, we don't think the DOL will be, really narrowly applying the 5-part test going forward. In the past, you could argue to escape fiduciary status. We think this 5-prong test will probably be interpreted, depending on what side of the fence you're on, either more broadly or more narrowly going forward, meaning you're just less likely to successfully argue that somehow you're not a fiduciary. So we're in a little bit of a limbo period. So people are, a lot of people are sticking with BIC-type solutions. They just think at the end of the day that's the trend of the industry. It's benign. It's in the participants' best interest. People have made internal changes in training. Firms can still, be profitable and successful, if you will, if that's your measure of success, without relying on, the old compensation mechanisms and what have you. And from, an enforcement perspective, if you look at, slide 39, even though just remember that even though the DOL rule has met its demise, states are moving forward with their own rules. I mean, clearly, we know Massachusetts had a very significant move that was well publicized with regard to Scottrade. We know that New York recently issued a best interest standard for life insurance and annuity sales. Life insurance, which really is not a product which is thought to have an investment element in it. New Jersey has some legislative activity around the disclosure of non-fiduciary status. Nevada was one of the early leaders in terms of imposing fiduciary duties on financial planners. Connecticut has a new requirement to disclose conflicts of interest, which will be effective, in a couple of weeks. But these are all legislative initiatives, and as I said before, Massachusetts took a different tack. They tried to, they took some enforcement action. So there's a lot out there. If you look at slide 40, we have a little bit of information there for you about some things that are happening in New York, from the New York Department of Financial Services. Kind of interesting to read about their activity there on slide 40 and 41. I think that's going to be a real leader for the country. Slide 42, we summarize some of the things that are happening in New Jersey. New Jersey has actually taken up two initiatives. The legislature has proposed legislation, and the Security Bureau has proposed a new fiduciary standard. So there's a lot going on there. At the end of the day, an advisor, if you're not acting as a fiduciary, an advisor, he, she, or it would have to disclose this fact. In plain English, I am not a fiduciary. That's pretty simple. Therefore, I'm not required to act in your best interest. I'm allowed to recommend investments that earn me more money than I otherwise would earn, even if those investments may not be the best for you, or the best combination of investments for you, or the right risk for you. That's pretty serious stuff. So we'll see where this is all going to go and how the trend will continue around the country. I believe the last time I checked that this legislation, I think the legislation aspect of this might have been stalled in New Jersey, with the elections and everything this year, but we'll see how things play. So there's also, we have more information on New Jersey, on the an announcement from the governor about the fiduciary standard. So, and they're looking for comments and feedback on that. I think there are some other states as well. Liv, were you going to pick up and talk about a few of the other state activities that are ongoing?
Sure. Very, very briefly, if we go to slide 44, Nevada, financial institutions and investment the advisors operating in Nevada became subject to a new state-imposed fiduciary duty effective, way back on July 1, 2017. And what it did was it had amended the definition of financial planner to include financial institutions, investment advisors, and their representatives. And so consequently, if these parties provide advice to Nevada-based clients, they will be subject to a state-mandated fiduciary duty. Now, this law also gives investors a means to sue financial planners for economic losses as well. If we move on to Connecticut, Connecticut has taken two approaches as well. On July 5th in 2017, it had passed a statute effective on that date that said that financial planners providing financial planning or investment advisory services to Connecticut consumers must disclose whether they are fiduciaries upon request. Now, as for Connecticut's second approach, beginning, at the start of next year on January 1st, 2019, Any company that administers a non-ERISA 403B plan offered by a political subdivision of the state of Connecticut to its employees has to disclose any conflicts of interest that the person has with the plan. So the disclosure has to be made upon the participant's enrollment in the plan and at least annually thereafter. Also, the disclosure must include the fee ratio and return, net of fees for each investment under the plan, the fees paid to any person who for compensation engages in providing investment advice to participants either directly or through publication or writings. So as Steve mentioned briefly, Massachusetts has taken kind of a different approach. Earlier this year, it sued Scottrade. It filed an administrative complaint and alleged that it violated Massachusetts state law. Now, according to the division, Scottrade adopted policies and procedures designed to comply with the fiduciary rule and the related prohibited transactions. What these policies said was that Scottrade wouldn't use contests that would cause its associates to make recommendations that are not in the interest of retirement accounts. Nevertheless, Scottrade launched 2 sales contests, the objectives of which were to generate new assets, including retirement assets, and it also offered cash prizes. So, you know, the division cried foul, and it clearly alleged that, you know, Scottrade violated its own internal policies related to the fiduciary rule, and this constituted a clear demonstration that Scottrade had failed to act in good faith to comply with the fiduciary rule. So Massachusetts is the first case in which there's an attempt to enforce the DOL's fiduciary rule. And although it alleges violation of state law only, its effect is to challenge a financial institution's compliance with it. So we think that if Massachusetts is successful, it could prompt a wave of similar lawsuits by some other states. So I think the takeaway here from the Massachusetts v. Scottrade situation is that policies and procedures that are in place have to be followed, and if a firm decides that the established policies and procedures are no longer appropriate, they should be changed.
Yeah, and just to build on that, stated otherwise, because this has come up with surprising frequency among our client base. A lot of people adopted certain policies and procedures, removed certain policies and procedures, made certain changes, made changes to their website content, advisory agreements, written disclosures, all with a view toward what was thought to be the inevitable implementation of the Fiduciary Act. Well, that didn't happen. So for many firms said, well, we can live with these policies and procedures. It's okay. We're going to keep them in place. At the end of the day, they work. And there you go. That's all set. But for firms who took those steps but have since decided they don't want to follow them all the way, they're going to vary or adapt or revise a little bit in light of the, you know, regulatory turn that was taken with the vacating of the fiduciary rule. You have to change your policy and procedure. That's the point. Once it's on the books, you have to follow it. So for those people who made changes in light of all this fiduciary activity from the DOL, if you don't want to live with those changes going forward, make sure you change your internal policies and procedures now.
Right. So just a quick update about the state of Maryland. So currently, Maryland, its investment advisors are already subject to a fiduciary standard of care. However, the Maryland Senate Finance Committee held a hearing very recently on October the 10th to discuss the best ways to address conflicts of interest among financial representatives who provide investment advice to consumers. One suggestion at this hearing was to extend the existing fiduciary duty standard that applies to investment advisors to all financial professionals who provide investment advice. So there's a little bit of an update there on Maryland.
That's great. Thank you. So where are we now in terms of these SEC and DOL rules we talked about? Well, We know that recently the DOL and the SEC, released their regulatory agendas for the upcoming year. They do that, I think, twice a year, semi-annual rulemaking agenda. And the SEC has targeted September 2019, as has the DOL. In terms of the SEC has said they've targeted 2019. That's not a guarantee or a deliverable due date. That's aspirational. We all know that oftentimes these dates are missed, but they've targeted September 2019 to finalize, this package of investment advice rulemaking that we talked about today. And the EBSA also has stated, that fiduciary rule cleanup regulations, if you will, to be finalized by September 2019. So we shall see what happens. Where that leaves us now, just to close, thank you all very much for your time. I think you can see the sheer enormity of all the things that are going on. And, you can imagine a transaction where potentially, the DOL, the SEC, insurance commissioners, you could have a lot of different jurisdictions or regulatory regimes, sticking a stake in the ground on a single transaction, claiming that it has the appropriate interpretation or jurisdiction to handle the matter. So there's a lot going on, and it's important for everyone to keep track of it. And I would also remind people that notwithstanding all the proposals that are out there, don't forget that what is old has now become new again. And, not only the 5-prong test, but there's a suite of prohibited transaction exemptions that are available. Some of them were modified to meet the BIC standard. That doesn't work. They revert to their old status now, but there's a suite of prohibited transactions available and offsetting mechanisms, if you will, and guidance that comes from DOL advisory opinions that can guide people through various investment transactions and structures and compensation schemes, which still have good standing. It's just a question of getting reacquainted with them and not relying, perhaps, for some on the BIC as much. So with that, Liv and I would like to say we hope you all had a wonderful Thanksgiving and enjoy the next couple of weeks as we close out the year. If you have any questions about, prohibited transactions or fiduciary standards or what have you, please reach out and contact Liv or I at the law firm, and we would be glad to respond to you. Thank you very much for your time, and we hope you have a great day.